Hello everyone and welcome back to my channel. This is Spring Porter with Spring Solutions LLC. In this video, I'm going to be discussing hearings on motions for unclaimed funds. It's not always called for unclaimed funds, but sometimes there are hearings. It's a rarity. I just want to ease your mind a little bit and not to obsess over this particular process. If you're interested, please stay tuned. Please note that I am not an attorney. This information is not indicated as legal advice. Please, if you have not subscribed to my channel, please do so. Please like my video. Please continue to share, and I would really appreciate that. Hi everyone, thanks again for tuning into my channel. So in this particular video, I wanted to go over a little bit more information pertaining to hearings, just to give you a little bit more insight. It's not something that you have to obsess over. It's not something that happens all the time in bankruptcy unclaimed funds. But just generally speaking, let's say if we're dealing with any other type of law like family law or regular civil litigation, anytime you file a motion, there's usually a hearing attached to that because there are two parties that maybe have opposing opinions on that subject matter. So yes, hearings are going to be necessary. When I worked for family law, I filed motions for divorce, motions for child support, for contempt, and things like that. That always came with a hearing. And again, both parties would go, they would review the documents, and then the judge would grant or deny the motion with an order, or he would just continue on that hearing for another date because no decision could be made. But with bankruptcy unclaimed funds, there really isn't an opposing side. It usually is the creditor that needs money back or the debtor that is getting money back. And that's essentially it. No one is typically objecting to those particular requests. I have not seen someone object to someone getting the money back, at least not the cases that I have reviewed. It probably does happen, but it's probably, again, a rarity because all debt has an expiration date. So for creditors coming after someone's unclaimed funds, it's probably they're not entitled to it anymore, usually because it's probably expired. So I don't want you to obsess over a hearing if it does happen. For unclaimed funds, it's usually not needed. All the other districts that I have worked besides Massachusetts, I haven't had to go to a hearing at all. I haven't had to call in for one because it was just the documents were there and the judge granted the order, the check came. So if something is missing or if there's clarity that needs to be had on your particular motion or a document, for example, you will probably get a hearing, or maybe they will just call you or email you, or they could just issue a deficiency notice and give you maybe 14 days or 15 days to cure that mistake or whatever is missing, and then you'll be fine. So I don't want you to be oh my god, I'm obsessed, I can't do this. One, just breathe. Two, you have your documents that you filed in, so you're able to review it. You want to get into the habit of reviewing things before you send it to the court, or maybe you want to just send it to me first before you put it in the mail and say, Spring, just look over this one more time. Totally fine. I would do that for you. But just always know that the court is never going to leave you in the dark completely. Even in my instance, I felt like I was being left in the dark in the state of Massachusetts because I kept following up and I was not getting a clear answer. But even then, I still got a response, which is a hearing. So either you're going to get, again, an email, a hearing, or you're going to get a deficiency notice. Somebody from the court will let you know what's going on with your case. You're never going to have to wonder. Okay, so again, we're third parties. Most of these districts are working with third parties. The judge knows that you're not an attorney. You will be fine. You can always get an attorney to handle the phone conference for you. Keep in mind that attorney is going to have to be licensed in the state where that bankruptcy case is. So remember that video that I told you how to find an attorney. Make sure you seek that video if that ever happens to you. Reach out to a bankruptcy attorney. Tell them what you're doing. Tell them you had a hearing coming up. You're unsure why they're calling a hearing. These are the documents that you filed. Make sure they have a copy of that. And then they can attend the 10-minute, maybe 10 or 15-minute phone conference for you. Mine was about 10 minutes. And it was something that I knew that I could handle on my own. So I didn't have to go seeking for an attorney because they are expensive. And for that 10 minutes, you probably are going to have to pay, I don't know, maybe $300 or whatever their rate is for them to review it and to go to that hearing. So just keep that in mind. That is always an option for you to have someone go to that hearing for you. I just wanted to basically come on and just don't to tell you don't obsess over it because it is a rarity. You don't always have to go to a hearing with bankruptcy unclaimed funds, okay? So I hope that that gives you a little bit more insight. Please continue to like, share, and subscribe to my channel if you have not done so already. And I will see you in the next video. Thanks for watching.